and they are panicking. Okay, so you know how Justin Baldoni filed that $400 million countersuit that has now since been dismissed? Well, overnight, Blake Lively filed a motion to compel, saying that they never fully turned over all of those documents from their countersuit that they referenced and cited and annotated and all the jazz, right? And now she wants them.
Blake Lively just made a move that has legal experts scratching their heads. After Justin Baldoni's $400 million countersuit was dismissed, most people would assume the case was over, but not Blake Lively. She is now demanding discovery from that very same dismissed case, claiming she needs to see everything Baldoni's team had planned to use against her.
They're asking for the court to remove privilege on a group text between Brian Friedman and some of the defendants. And her argument is the same that she has been kind of arguing up until this point, that he wasn't actually being a lawyer. He was being their PR person. And this is where I think things get a little brave, as they go, just because Nathan and Abel were on the group text with Brian Friedman, they're saying that this served as Wayfair's defendant media strategy and destroyed any claim of attorney-client privilege.
Could this aggressive legal strategy actually backfire? Or is this a calculated move that reveals just how desperate things have become? What we are seeing unfold right now could change everything we thought we knew about this Hollywood legal battle. Here is what happened overnight. Blake Lively filed a motion to compel discovery, essentially telling the court that even though Baldoni's countersuit was dismissed, she still wants access to all the documents, communications, and evidence his legal team had gathered. This is not your typical post-dismissal request. In fact, legal experts are calling it one of the most aggressive discovery moves they have seen in a celebrity case.
I cackled a little bit at this one. He didn't give the video of his wife giving birth. Like, he hasn't turned that over yet.
The motion specifically targets several explosive areas, and each one reveals a different aspect of Lively's legal strategy. First, and perhaps most damaging, Lively is demanding access to group text messages between Brian Friedman, who served as Baldoni's attorney, and other defendants in the case. Her argument is stunning in its boldness. She claims Friedman was not actually functioning as a lawyer, but as a public relations strategist, which would strip away attorney-client privilege protections.
It honestly looks like she doesn't have what she needs, and I don't know. They're going back to a dismissed case that they're probably going to have a very hard time fighting to get. I don't know, maybe not. I need that's why I've been waiting all morning for somebody smarter than me to go over this, but nobody else is coming in. So I'm going to ask my questions, and my questions are, are they allowed to go and actually go back and say, I know your case is dismissed, but we need all the discovery from that? Like, I don't think but then I don't know, because all of those cases are so intermixed.
But here's where it gets legally fascinating. The group texts allegedly included Nathan Kahane and Jamie Heath, who were not just random participants. They were actively involved in the litigation as defendants, while simultaneously working on media strategy. Lively's team argues that this dual role destroyed any claim to attorney-client privilege. In simple terms, when you mix legal advice with PR strategy in the same conversation, you might lose the legal protections that normally keep those communications private.
The judge needed the whole transcript for the small portion they were quoting. No.
So now we've got Attorney McCaffrey discussing Blake trying to get the transcript of the deposition removed. They included it as an exhibit, even though it was, sealed or whatever. They included it as an exhibit to reference something they were mentioning. But again, it's very normal for that to happen.
Think about the implications here. If a judge agrees that Friedman was doing PR work instead of legal work, those private communications become fair game. Every strategy session, every discussion about how to handle Blake Lively, every piece of advice given about managing the media narrative could potentially be exposed. We could see internal discussions about how to discredit Lively, how to shape public opinion, and how to coordinate their legal and media responses. So,
do I and other lawyers I routinely am against just file the whole deposition transcript if I'm using it as an exhibit in a motion? Yes. I think I referenced that motion for summary judgment that I was working on.
The legal precedent this could set is enormous. If successful, Lively's argument could fundamentally change how attorneys handle high-profile cases. Law firms might need to completely separate their legal teams from their PR consultants to avoid losing privilege protections. But the most bizarre demand in the entire motion involves a water birth video featuring Justin Baldoni's wife. Yes, you heard that correctly. This is the same video that Lively previously complained about being shown during the production process, claiming it made her uncomfortable and was inappropriate workplace behavior. Now she wants to examine it herself, claiming it could help jog her memory about events that occurred on set.
Lil girl attorney offering her opinion that Blake Lively has dirty tactics that she's using to come after Justin Baldoni's attorney.
Abe is trying to do is make Brian Friedman into a fact witness in this case. If he is a fact witness in this case, then discovery is relevant to support Lively's claims.
Contradiction here is striking. Lively's original complaint suggested that being shown this video was part of the hostile work environment she experienced. Now she is actively seeking access to the same material. Critics are pointing out that Baldoni had posted portions of this birth experience on his own social media, making it hardly the private, invasive content that Lively's team originally portrayed it as. Legal experts are divided on this particular demand. Some see it as Lively's team being thorough in their discovery requests. Others view it as an attempt to embarrass Baldoni by forcing him to turn over personal family moments, even those he had previously shared publicly.
So the judge will have to weigh whether or not Friedman being a potential fact witness in this case outweighs the potential risk of producing work product or privileged information.
The timing of these demands is also strategically significant. By waiting until after Baldoni dismissed his countersuit, Lively's team avoided the normal reciprocal discovery process. Under typical circumstances, if she demanded this level of access to his materials, his team could have demanded equal access to her communications and documents. But with his case dismissed, the discovery flow becomes one-directional. There is another layer to consider here. Lively's motion also demands access to sealed deposition transcripts that Baldoni's team had referenced in their now-dismissed case. She argues that because they cited these transcripts in their legal filings, they waived any confidentiality protections. This is a legal argument that could have implications far beyond this case. The legal community is split on whether this strategy will work. Some experts are calling it a desperate fishing expedition, suggesting that Lively's team does not have the evidence they need for their original case, and are hoping to find it in Baldoni's materials. Others believe Lively's team has identified genuine weaknesses in how Baldoni's side handled privileged communications, and are exploiting those vulnerabilities brilliantly. The most telling aspect of this entire discovery battle might be what it reveals about the confidence level of both legal teams. If Lively's case was as strong as initially presented, would her team need to take such aggressive steps to obtain additional evidence? Conversely, if Baldoni's team had nothing to hide, why dismiss the countersuit rather than proceed to discovery, where both sides would have equal access to each other's materials? Why would Blake Lively risk appearing overly aggressive with these demands? The answer might reveal just how much pressure her legal team is feeling right now. These are not the moves of a legal team that feels confident about their existing evidence. These are the moves of attorneys who believe they need additional ammunition to win their case. Let us rewind for a moment to understand how we got to this unprecedented situation. The entire legal battle stems from Blake Lively's initial complaint against Justin Baldoni, where she accused him of sexual harassment and creating a hostile work environment during the filming of It Ends With Us. Baldoni responded with that massive $400 million countersuit, claiming Lively had destroyed his reputation and career prospects through false allegations. That countersuit painted a picture of Lively as the real problem on set, someone who made unreasonable demands and created the very hostile environment she later complained about. But here is where things took an unexpected turn. Baldoni's legal team made what many now see as a critical error. They dismissed their own countersuit, likely believing it would strengthen their position in the original case. Instead, it opened the door for exactly what we are seeing now. The dismissal was supposed to simplify the legal landscape. Instead, it has created this unusual situation where Lively can argue she needs access to materials from a case that technically no longer exists. It is a legal gray area that could set important precedents for how dismissed cases are handled in the future. From a legal standpoint, what Blake Lively is attempting here walks a very fine line. In simple terms, She is arguing that even though Baldoni dismissed his case, the discovery materials he gathered are still relevant to her ongoing claims. This is not typically how the legal system works. When a case is dismissed, the general expectation is that associated discovery materials remain with the parties who gathered them. But Lively's team is making a creative argument. They claim that because all these cases are interconnected, and because some of the materials might contain evidence of attorney-client privilege violations, the normal rules should not apply. The privilege issue is particularly complex. Attorney-client privilege is one of the strongest protections in the legal system, but it can be waived if the attorney steps outside their role as legal counsel. If Brian Friedman was indeed coordinating public relations strategy while also providing legal advice, it could create what lawyers call a waiver of privilege. The inclusion of PR professionals in group communications with the attorney adds another layer of complexity. In simple terms, when lawyers include non-lawyers in confidential communications, it can destroy the privilege that would normally protect those conversations. This could be a brilliant legal strategy or a costly mistake. If the judge agrees with Lively's arguments, it could expose Baldoni's entire litigation strategy. If the judge rejects them, it could make Lively appear desperate and overreaching. The broader legal community is watching this case closely because it could establish new precedents for how mixed legal and PR strategies are handled in high-profile cases. This case is revealing something important about how celebrity legal battles are fought in the social media age. The line between legal strategy and public relations has become increasingly blurred, and courts are struggling to keep up with these new realities. If Blake Lively succeeds in her discovery demands, it could fundamentally change how attorneys approach high-profile cases. Law firms might need to completely separate their legal and PR functions to avoid privilege issues. The cost and complexity of celebrity litigation could increase dramatically. But there is another possibility that nobody is talking about openly. What if this entire discovery battle is actually a negotiation tactic? By making these aggressive demands, Lively's team might be trying to pressure Baldoni into a settlement. After all, the threat of having privileged communications exposed could be more powerful than actually exposing them. The timing is also suspicious. Why make these demands now, after the countersuit has been dismissed? It suggests that Lively's team might not be as confident in their case as they initially appeared. They might be looking for additional ammunition or trying to find evidence that could shift public opinion back in their favor. There is also the question of what this reveals about how the entertainment industry really works. The casual mention of sweet-talking actors to ensure cooperation, the blending of legal and PR strategies, the assumption that everyone in Hollywood operates with hidden agendas, it paints a picture of an industry where authentic relationships are rare. For Justin Baldoni, this discovery battle represents a new front in what was supposed to be a concluded legal matter. His team now has to decide whether to fight these demands aggressively or try to minimize the damage through partial compliance. The judge in this case essentially holds the power to reshape how celebrity legal battles are conducted going forward. Will the court prioritize traditional legal protections like attorney-client privilege, or will it adapt to the new reality where legal and PR strategies are inseparable? What we are witnessing here goes beyond just another Hollywood legal battle. This case is testing the limits of our legal system when it collides with modern celebrity culture and social media dynamics. The most fascinating aspect is how both sides seem to be playing for different audiences. Blake Lively appears to be fighting for legal vindication and public support. Justin Baldoni seems to be fighting for professional survival and reputation recovery. Neither side can win completely without destroying the other. The discovery demands reveal something crucial about litigation strategy in the digital age. When every communication might become public, when every legal filing gets analyzed by content creators and legal experts online, traditional litigation tactics have to evolve. If you are following this case, pay attention to how the judge rules on these discovery demands. It will tell us whether courts are ready to adapt to these new realities or whether they will stick to traditional approaches that might not fit modern celebrity disputes. The broader question is whether our legal system can handle cases where the line between law, public relations, and entertainment has completely disappeared. This case might be the test case that determines how we handle celebrity legal battles for years to come. And here's the question that should keep everyone interested in this case awake at night. If Blake Lively gets access to these materials and they do not contain the smoking gun evidence she needs, what happens next? Does this case spiral into an even more destructive legal battle, or does it finally force both sides to find a resolution? The stakes could not be higher for both Blake Lively and Justin Baldoni. Their careers, their reputations, and potentially their financial futures hang in the balance. The legal system is about to decide not just the outcome of their dispute, but how similar disputes will be handled in our increasingly connected and transparent world. What do you think about Blake Lively's aggressive discovery demands? Is this a smart legal strategy or a sign of desperation? And do you believe the traditional protections like attorney-client privilege should apply when lawyers are also coordinating public relations campaigns? Let us know your thoughts in the comments below, because this case is far from over, and your perspective matters as we continue following this unprecedented legal battle.
Courtroom chaos? The judges blocked the subpoenas of Justin Baldoni's lawyer as Blake Lively filed here to explain it all.
Courtroom chaos erupts as a federal judge delivers a stunning ruling that could reshape the entire Blake Lively versus Justin Baldoni legal war. In a dramatic turn of events, the court has blocked Blake Lively's aggressive subpoena attempts targeting Baldoni's legal team, but that's just the beginning of this explosive story.
The judge has now blocked Blake Lively's subpoenas of Justin Baldoni's legal team. I mean, this was expected. It's not pretty typical to be able to get stuff from the lawyer and his clients. That's privilege.
Because while Lively celebrates what appears to be a partial victory, she's simultaneously launching a nuclear option, filing for sanctions against Baldoni's high-profile attorney, Brian Friedman. The question everyone's asking tonight, could this backfire spectacularly and land her legal team in hot water instead? What you're about to discover will shock you.
Beyond that, specific communications will not be handed over, correct? Was this the right verdict? And can you sort of explain to the audience what this all means?
Yeah, so the judge took a very tempered view and I think specific view as to what each individual request is asking for, splitting them into three categories. So
strategic missteps, leaked transcripts, and courtroom blunders that could determine whether justice prevails or if Hollywood's power players can manipulate the system. Was this all a carefully calculated setup, or is someone about to learn a very expensive lesson about crossing the line in federal court? The bombshell ruling from Judge Lewis Lyman has sent shockwaves through both legal camps, but the devil is in the details, and those details reveal a far more complex picture than either side wants you to see.
the judge is taking the attorney's word for it, Liner's word for it, like there are no responsive documents, and the judge goes, okay, until you tell me they're lying, I have to take their word for it, let's move on. I think that's very, very, astute way of doing it.
Here's what actually happened. Blake Lively's legal team launched an unprecedented attack on the heart of attorney-client privilege itself. They didn't just want documents. They wanted to crack open the entire strategic playbook of Justin Baldoni's defense team. Their subpoenas targeted Brian Friedman's law firm demanding access to privileged attorney-client communications, internal strategy documents, correspondence with content creators, and essentially any communication that could reveal how Baldoni's team has been defending this case.
But then regarding specific communications and the other sort of requests for productions, that's where he said no.
Yeah, so in the other two, he said no. And again, he took a very, very specific category by category analysis. So for the second one, had to do with documents between
communications and concerning content and more media generally.
This wasn't a fishing expedition. This was dynamite fishing. Lively's attorneys were asking the court to blow up one of the most fundamental protections in the legal system, the sacred bond between lawyer and client. Judge Lyman saw exactly what was happening and responded with surgical precision that reveals just how experienced he is with these high-stakes celebrity battles. Instead of issuing a blanket ruling, he dissected Lively's subpoena requests like a master surgeon, dividing them into 3 distinct categories, each with different legal implications and strategic consequences.
As if you have more to tell me, listen, we've tried everything under the sun to get this another way and it's not working, we need to come back, then if the judge is satisfied with those efforts that don't bring to fruition, then he will reconsider this, which I thought was very, very interesting.
The first category involved general documents related to content creators that Friedman's firm represents outside of this specific lawsuit. Here's where things get fascinating. In open court, Friedman's team made what could be seen as either a brilliant strategic move or a devastating tactical error. They stated unequivocally that no documents exist regarding the specific content creators that Lively is concerned about. Think about the implications of this submission. Either Friedman's team is telling the absolute truth, and there really is no coordinated campaign with content creators, or they're playing an incredibly dangerous game by making false statements to a federal judge. There's no middle ground here.
Begin with. So is it not okay for Friedman's team to be out there speaking to press or creators to say, here's our official statement, or here's the evidence that dropped that's part of our legal documents? Where is the line as to what's allowed and what's retaliation in your mind?
That's a great point. So under the litigation privilege that exists in every state, California, New York, things that anybody say connected to what's called a pending judicial proceeding like this is privileged under the litigation privilege from suing, because that would be a suppression of our ability to bring grievances to the court.
Judge Lyman essentially responded, if these documents don't exist, then no harm, no foul. He granted protection for unrelated content creator relationships while simultaneously denying the request for documents that supposedly don't exist anyway. It was a masterclass in judicial efficiency that managed to protect legitimate attorney-client relationships while calling everyone's bluff. But here's where the ruling gets truly explosive, and where Brian Friedman might have made his first major strategic miscalculation. For the second and third categories of requests, which involved specific communications between Friedman and media outlets, plus any documents related to media strategy and public relations campaigns, Judge Lyman delivered a resounding and unequivocal no.
Clear, like he's allowed to speak to the press about the case. That's because that's what's weirdly being, I feel like, spun in the narrative of Blake, is that any communication Wayfarer parties, anybody, whatever them had with press sort of defending themselves with statements is somehow part of the retaliation campaign or ongoing smear campaign. And you're legal. That's not the case. They're allowed to defend themselves.
Yeah, they're allowed to defend themselves. They're allowed to make statements about defending themselves. That's absolutely above board. That's 100% above water.
The judge didn't just cite attorney-client privilege. He went further, noting that these requests were overly burdensome and potentially violated established legal protections. But here's the part that should terrify Lively's legal team. He specifically mentioned that there seemed to be a disconnect between their original complaint and these new discovery demands. In judicial language, that's basically the judge saying, "You're changing your story, and I've noticed." However, and this is the detail that changes everything, Judge Lyman used the phrase "without prejudice." This isn't just legal terminology, it's a strategic roadmap. What the judge is essentially telling Lively's team is, "I'm not shutting this door forever, but you're going about this completely wrong."
So is there a part of this where they've gone too far? Could these sanctions be actually, given?
So it depends what the judge is going to cling on to, is what is the conduct that's violating, what we call violative conduct that empowers the judge to sanction anybody, right?
The judge made it crystal clear. If you want this information, find a less intrusive way to get it. Talk to the content creators directly. Subpoena them instead of going after the attorney. Use traditional discovery methods before you try to blow up attorney-client privilege. This ruling reveals something absolutely fascinating about judicial thinking in the digital age. Courts want to protect attorney-client privilege while still allowing legitimate discovery, but they're not going to let parties use modern media warfare as an excuse to destroy fundamental legal protections. The judge is essentially saying, just because this case involves social media and content creators doesn't mean we're throwing out centuries of legal precedent. But was this really a win for Baldoni's team? The answer is far more complicated than either side wants to admit. Yes, they avoided the immediate threat of having their privileged communications exposed. But they also made several admissions under oath that could come back to haunt them. Meanwhile, Blake Lively's team learned something crucial about Judge Lyman's approach to this case. He's not going to be bullied or manipulated by celebrity status or media pressure. He's going to follow established legal procedures and precedents, regardless of how famous the parties involved might be. The real question becomes, why did Lively's team choose this approach in the first place? Did they genuinely believe they could convince a federal judge to ignore attorney-client privilege? Or was this entire subpoena strategy designed to fail publicly and create ammunition for their sanctions motion?
Watch me debunk
Because while Baldoni's team celebrated avoiding the subpoenas, Brian Friedman's conduct outside the courtroom was about to become the center of an even bigger controversy. Let's rewind for a second and understand how we got to this explosive moment. This legal battle began when Blake Lively filed a complaint with the California Civil Rights Department, alleging sexual harassment and a coordinated smear campaign against her during and after the filming of It Ends With Us. That complaint contained detailed evidence and personal communications, material that statements must be connected to the legal proceeding and serve a legitimate purpose in the litigation. Brian Friedman's media appearances defending Baldoni likely fall within acceptable bounds. Attorneys have the right to make public statements about their cases and defend their clients' reputations. The key question is whether any private communications between Friedman and content creators crossed ethical lines. Blake Lively's team is essentially arguing that Friedman orchestrated a coordinated campaign using content creators to amplify negative narratives about her. They want to prove there was a secret strategy involving specific talking points and coordinated messaging. In simple terms, this means they're trying to show the difference between legitimate defense and orchestrated retaliation. If they can prove Friedman was telling content creators exactly what to say and when to say it, that could constitute proper conduct. But here's the strategic problem for Lively's team. They chose the most difficult path to prove their case. Instead of directly subpoenaing content creators, who don't have attorney-client privilege protection, they went after the lawyer first.
El rey de las fiestas más oscuras se encuentra en el centro de un quilombo cósmico que explotó el 25 de marzo cuando agentes del Departamento de Seguridad Nacional allanaron la mansión multimillonaria de Sean Diddy Combs en Los Ángeles, al igual que su casa.
When filing documents with the court, Friedman's team attached an entire deposition transcript instead of just the relevant excerpts they needed to support their argument. Legal experts are calling this a massive blunder that violates standard litigation practices. Here's why this matters. Deposition transcripts contain sensitive information, personal details, and strategic insights that should remain confidential until properly redacted and presented. By filing the entire transcript, Friedman potentially exposed privileged information and gave the public access to far more details than necessary. Blake Lively's team immediately pounced on this mistake, using it as the foundation for their sanctions motion. They're arguing that Friedman deliberately leaked sensitive information to influence public opinion and potential jurors. But there's a deeper issue here that reveals the high-stakes nature of this case. The transcript allegedly contains information about who was present during depositions, what was discussed, and strategic details about both sides' cases. This information is now part of the public record, even if redacted. The sanctions motion paints a picture of an attorney who has repeatedly pushed ethical boundaries. Lively's team points to previous incidents, including a letter that was struck from the record for containing inappropriate information about Taylor Swift and other irrelevant details. They're also challenging specific quotes and statements attributed to Friedman in media interviews, claiming he made inflammatory comments designed to prejudice potential jurors. However, some of these allegations appear to be misattributed. Statements that were actually made by media personalities like Megyn Kelly are being blamed on Friedman. This pattern suggests that both sides are engaged in narrative warfare that extends far beyond the courtroom. Each side is trying to control public perception while simultaneously fighting the legal battle. The potential consequences are severe. If Judge Lyman determines that Friedman violated court rules or ethical standards, he could face monetary sanctions, restrictions on his ability to file documents, or even more serious disciplinary action. The sanctions motion represents a pivotal moment that could determine the trajectory of this entire case. But what are the realistic chances that Brian Friedman faces serious consequences? Legal experts suggest that judges typically start with modest monetary sanctions for first-time procedural violations, perhaps $4,000 to $5,000. It's designed to send a message without crippling the attorney's ability to represent their client. However, this isn't Friedman's first alleged misstep. The previous incident involving the Taylor Swift letter that was struck from the record establishes a pattern of pushing boundaries. Judges don't like patterns of problematic behavior, especially when they've already issued warnings. The critical factor will be Judge Lyman's determination about intent. Was the full transcript filing an honest mistake, or was it a deliberate attempt to leak information into the public domain? If the court believes it was intentional, the consequences could be much more severe than monetary sanctions. The judge could impose what are called evidentiary sanctions or issue sanctions, essentially preventing Friedman's team from presenting certain evidence or arguments. In extreme cases, courts can even dismiss claims or defenses entirely. But there's another layer to consider: the court of public opinion. By filing for sanctions, Blake Lively's team is essentially arguing that they're the victims of an unethical smear campaign orchestrated by opposing counsel. This narrative positions them as the party fighting fairly, while their opponents break the rules. However, this strategy carries risks. If the sanctions motion fails or appears frivolous, it could backfire and make Lively's team appear overly aggressive or vindictive. Judges don't appreciate frivolous sanctions motions, which can result in counter-sanctions against the filing party. The timing of this motion is also strategically significant. It comes immediately after the subpoena ruling, which suggests Lively's team is trying to maintain momentum and pressure after a mixed result on their discovery requests. This case raises fundamental questions about how the legal system handles celebrity disputes and whether famous plaintiffs receive different treatment than ordinary citizens. Blake Lively's initial decision to file a public civil rights department complaint, complete with detailed evidence and personal communications, was highly unusual. Most employment disputes are handled privately through confidential settlements or sealed court proceedings. By making her allegations public from the beginning, Lively essentially forced this case into the spotlight and created the media circus that now surrounds every filing and ruling. This tactical choice gave her control over the initial narrative.
The tide is truly turning as reporters.
Justin Baldoni's response, hiring a high-profile media-savvy attorney and fighting back publicly, represents the natural evolution of celebrity legal disputes in the social media age. Both sides recognize that public perception can be as important as courtroom victories. But this approach creates new ethical challenges for the legal system. When attorneys become media personalities and court filings become public relations documents, traditional boundaries between legal advocacy and public relations work become blurred. The broader implications extend beyond this case. If Lively succeeds in establishing that aggressive public defense constitutes improper retaliation, it could create a chilling effect on how attorneys defend their clients in high-profile cases. Conversely, if Baldoni's team prevails in arguing that their public statements are protected litigation privilege, it could establish broader protections for attorneys who engage in media advocacy. The entertainment industry is watching closely because this case could set precedents for how sexual harassment allegations, defamation claims, and media strategy intersect in the legal system. As this legal drama continues to unfold, several critical developments will determine the ultimate outcome and broader implications. Judge Lyman's ruling on the sanctions motion will be the next major inflection point. If he sides with Blake Lively and imposes meaningful sanctions on Brian Friedman, it will signal that courts are willing to police attorney conduct in high-profile cases more aggressively. However, if the sanctions motion fails, it could embolden Baldoni's team to pursue even more aggressive tactics and potentially file counter-sanctions against Lively's attorneys for frivolous motions. The discovery process will ultimately determine which side has stronger evidence. Lively's team still has options for obtaining the communications they want. They can subpoena content creators directly, pursue other avenues for evidence gathering, and continue building their case through traditional litigation channels. Meanwhile, Baldoni's team will likely file their own motions challenging the underlying legal theories in Lively's case. They may argue that her retaliation claims are barred by litigation privilege and First Amendment protections. The financial stakes continue to escalate with each filing. Both sides are reportedly spending enormous sums on legal fees, suggesting that neither is prepared to back down or seek early settlement. Perhaps most significantly, this case is becoming a referendum on power dynamics in Hollywood and whether the legal system can adequately address complex disputes involving celebrity status, media manipulation, and competing narratives about sexual harassment and defamation. The outcome will likely influence how future celebrity legal disputes are handled and could establish new boundaries for attorney conduct in high-profile litigation. The Blake Lively versus Justin Baldoni legal war has evolved into something far more significant than a typical Hollywood dispute. It's become a battleground for fundamental questions about legal ethics, celebrity justice, and the intersection of litigation and public relations in the digital age. While Judge Lyman blocked the attorney subpoenas, the sanctions motion represents the real test of whether aggressive legal advocacy crosses ethical lines. Brian Friedman's pattern of controversial filings and media statements has put him in a precarious position where one more misstep could have serious professional consequences. Blake Lively's strategic decision to fight publicly from the beginning has created opportunities and risks that will ultimately determine whether she achieves justice or faces a devastating legal defeat. The entertainment industry, legal profession, and public are all watching to see whether the system can handle celebrity disputes fairly and whether truth ultimately prevails over narrative manipulation. And if this case moves forward to trial, it could expose everything about how power, celebrity status, and media strategy intersect with the pursuit of justice in America. What do you think? Is Brian Friedman crossing ethical lines? Or is Blake Lively trying to weaponize the court system to silence legitimate defense? Could these sanctions backfire and damage her credibility with the judge? Drop your take in the comments below, and let us know which side you think is winning this high-stakes legal chess match. Stay tuned, because this story is far from over, and the next ruling could change everything.
Courtroom chaos? The judges blocked the subpoenas of Justin Baldoni's lawyer as Blake Lively files for sanctions. We got Ron Zambrano here to explain it all.
Courtroom chaos erupts as a federal judge delivers a stunning ruling that could reshape the entire Blake Lively versus Justin Baldoni legal war. In a dramatic turn of events, the court has blocked Blake Lively's aggressive subpoena attempts targeting Baldoni's legal team, but that's just the beginning of this explosive story.
The judge has now blocked Blake Lively's subpoenas of Justin Baldoni's legal team. I mean, this was expected. It's not pretty typical to be able to get stuff from the lawyer and his clients. That's privilege.
Because while Lively celebrates what appears to be a partial victory, she's simultaneously launching a nuclear option.
New text messages have been revealed from an It Ends With Us editor that exposes the control that Blake Lively had on the project. Also, Blake Lively's team has responded to that deposition reveal.
You made us promise that in no season would your character ever be locked in a cage.
we all remember Savannah.
It was another promise was no pet monkey. Chuck has a matching pet monkey with coordinating outfits, and I was like, I would love to be part of the show, but I can't act with a monkey. Then I got a few of them.
She got a few of them.
Come on, it was a joke.
Who else didn't want to act in a cage?
Well, some of them
required a cage.
Explosive new text messages have just surfaced that could completely change everything we thought we knew about Blake Lively's involvement in It Ends With Us. These aren't just any messages. They're internal communications between film editors that reveal the shocking extent of control Lively demanded over scenes she wasn't even in. But here's the twist that nobody saw coming. Blake Lively allegedly forced her way into having approval rights over scenes featuring the young actress playing her teenage character. Was this creative collaboration? Or was it a calculated power grab that crossed every professional boundary in Hollywood?
It was a scene involving young Lily. Let's go straight to the text. Here they are as part of an exhibit where personal details such as phone numbers have been removed. But this individual, Henry Grace, is the owner of this chat that seemed to have JB as well, was an owner as well, along with Rob and Una, who were editors on the project. JB, I can only assume, is...
The messages don't just expose control. They reveal frustration, manipulation, and what appears to be a systematic takeover of a project that wasn't hers to control. Could these revelations be the smoking gun that destroys her legal case entirely? The newly leaked text messages between film editors reveal what can only be described as a systematic takeover attempt. These conversations between Henry Grace, Rob, and Una aren't just casual workplace complaints. They're official court exhibits that expose the shocking reality of Blake Lively's behavior during production.
Justin Baldoni. But Henry chimes in, done. PG-13, says Una. No adjustments. I guess this is getting the film or the trailer through. Yep, great news. Woo, woohoo, Rob says. Exclamation point, exclamation point. So are we keeping the thrust? I'll drink to that, Rob says. Of course, I plan on drinking anyway. But then Henry chimes in, that's going to end up being a Blake call. Honestly, if you can get her to keep it in and it's in the movie when I get back, it can stay in. She has approval of that scene.
Let's break down exactly what happened, step by step. The conversation begins innocuously enough. The editors are discussing getting approval for what appears to be a trailer or film cut. Una mentions PG-13 and no adjustments, suggesting they've successfully navigated ratings requirements. Their celebration, hot done. Woot. Woohoo. The kind of relief that comes from clearing a major hurdle.
Because she wasn't part of writing that scene and didn't want a character depicting her to have X in high school, honestly, it's all about control, and so she could get to what she would be next week, all good. Hi, Rob. Now, here's what's frustrating. If she had read the book, she'd know that's what happens in the damn book.
But then the conversation takes a dark turn. Rob asks, so, are we keeping the thrust? This appears to reference